Hello everyone, it's Tom Nevin here from Lockwood to Witness Training, and today we're going to look at some general tips for all witnesses when giving evidence under cross-examination. So today we're looking at some general tips for all witnesses when giving evidence under cross-examination. This applies to both lay, i.e. factual witnesses, and also to experts as well. There's a lot of information out there, but we have a particular focus on Australia. That's where we do most of our training, and that's where our courses are developed, and that's the legal system our courses are developed for. So this brief overview, and indeed the training that we do more generally, has that Australian focus, and I think that's important for anyone who is involved in proceedings within Australia. As the name suggests as well, it's a very general overview. There is a lot to be said on this topic, and we can't cover anything like the amount of detail we'd like to in this short session. You'll also note that a lot of this seems fairly straightforward and obvious. Indeed, some of it seems that way, but you'll be amazed by how many witnesses do not in fact do this when under the pressure and stresses of cross-examination. So it's well worth remembering and reminding you of if you are going to be involved in giving evidence under cross-examination. Before we start, a little bit about us here at Lockwood. What we do is on the screen there. We do witness training throughout Australia, courses available in person in most cities, and also by video link as well. We have specific courses for lay, i.e. factual witnesses, and experts as well as professional witnesses. These courses obviously go into a lot more detail and provide many more strategies and tactics which are used by barristers in cross-examination. And they also show you as a witness how you can firstly recognise what is being done and perhaps most importantly to respond effectively when it is done. These courses also give you a chance to practice what you've learned through a series of mock cross-examinations. So to the content, the first tip for all experts when giving evidence under cross-examination is that you should know your materials very well. But you should also know the relevant materials of all the other witnesses who are providing evidence. It goes without saying that the point of cross-examination is to challenge you on your evidence, and so you should go through your statement and each sentence in particular and see how you can explain or justify it if you are challenged on it. You should also look at the opposing witness statements to see where they contradict or challenge your evidence and how you explain those differences. You need to be sure of each sentence. You need to look for imprecise words, for example, about or nearly. You'll be quizzed on them, be cross-examined on them. If there are other witnesses whose evidence contradicts yours, you need to be able to explain why yours is correct. It might be, for example, the meeting in question was definitely on that date. My meeting notes are here and the date is referenced in those notes. I think the other witness may be referring to an earlier meeting we had the week prior, or something very direct. Mrs. X might think the car was green, but the car that I saw was most definitely yellow. Something simple like that, as long as you've thought about it and you are prepared for questions on the specific challenges. Point number 2, and that's to take a breath before giving any answer. This forces you to pause, it forces you to think, and it will also calm you down. It will allow you to speak more effectively and to hopefully avoid getting flustered. It also avoids the use of filler words, and etc. Again, this is quite simple, but it's very important and often overlooked, and it's also quite hard to do in practice. You'll be surprised. It avoids getting you to say something in the heat of the moment, and sometimes this is what barristers want. They want to get you into a position where they're firing questions at you and you're firing responses back, perhaps without thinking. It also gets you to avoid the habit of answering questions in a certain way. It's quite a common strategy for barristers to ask you a series of questions where you reply yes, 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 and then the final question you reply yes without thinking, but you perhaps would have qualified that yes, or it might even be a no. If you've taken a breath beforehand, you've paused, you've composed yourself before answering, you've thought, most importantly, and you'll be able to answer more effectively your own evidence, and you won't fall into that trap, or perhaps there's a less likely chance that you'll fall into that trap. You'll also come across to the judge as more considered, and indeed you'll actually be more considered in your actual responses given. So simple point, but there's a lot in it, and that's take a breath before giving any answer. Point number 3, and that's to direct your answer to the judge or the jury and not to the advocate asking you the questions. Now, as a witness, your role is to tell the court something, what you saw, what you observed, and you want to be as convincing as possible in this, and obviously to appear and be as honest as possible. Now, it's the court or the jury that makes the decision on the case. It's not the cross-examining counsel. You can't convince the cross-examining counsel. That barrister is paid to pick holes in your statement and to discredit you. That barrister or counsel is not going to be convinced whatever you say. You have to convince the judge or the jury if it's a criminal trial. You should also read the judge or the jury, but mainly the judge's verbal or other cues. For example, if they are writing something down, you should stop and let them let them write it down while you've paused. Let them finish writing it down and perhaps continue your answer. They're writing down a specific point in relation to your evidence. You want to give them that chance to do so. Tip number 4 is to keep answers short and concise. Again, perhaps it might seem somewhat self-evident to do this, but again, in practice, it's one of those things that doesn't always happen. You don't want to say more than you need to, and you should listen carefully to the question asked, and should also answer the question that's actually asked of you. Now, getting a witness to ramble on with a long-winded, vague answer is a genuine tactic that is used by barristers, because people invariably will say too much. A simple yes, no, or I don't know are all perfectly acceptable responses. The 5th tip is to enjoy the silence. And this tip in a way relates to the one we just mentioned. It's a common tactic for cross-examining counsel to pause and have a silence. And people have a tendency to talk during silences. And as a witness, you should avoid and resist that urge to talk constantly or continually during a silence. What you should in fact do is to use that silence to your advantage and try and resettle yourself and recompose yourself. And the barrister might be cross-examining you, and they might even pause and exaggerate with great effect. They'll peer over their glasses at you and stare at you. You'll feel uncomfortable. Now resist the urge to keep talking. Enjoy that silence. Rather than looking at the barrister, look at the judge or the jury. This will probably make you less inclined to speak unnecessarily. The 6th tip is, if you get flustered, and you may well get flustered, to pause, recompose yourself, and perhaps even have a drink of water. It does give you that moment to sort of break the cross-examination, breaks the flow of the cross-examination. You get a chance to recompose yourself, and then you can continue. So there's some very simple and general points to help all the witnesses in cross-examination. We could go on about many of these in much, much greater detail, and indeed we teach these and many, many others in our courses. We teach some very advanced strategies and countermeasures. We also give people the chance to practice what they've learned in a series of practical mock cross-examinations. We do this for experts, for factual witnesses, and also professional witnesses. If you have any questions, please note them in the comments or send an email. If you would like a video on any other topic, again, just let us know in the comments or send us an email. Please, of course, share this with anyone else who you think may benefit from it. And the plan is for this video to be part of a series. The next will be on specific strategies for expert witnesses in cross-examination. And we'll leave a link for that one below. So that concludes our brief look at some of the general points for witnesses during cross-examination. I hope that you found it useful and very interesting. Thank you for your time.